I want to be respectful of everyone's time, so it is 7 o'clock. We will get started. I want to thank everyone for coming out tonight. My name, as it says up there on the slide, is Russell Blair, Director of Education and Communications at the Freedom of Information Commission, and my job is to go across the state, do these training sessions to anyone who will have me. So I always make a pitch. Obviously you were all here because you're involved in Suffield, but if you're involved in another town, you find this helpful, you can always call the office, and we're happy to set this up. If you work in another town hall or something like that, and you think it would be beneficial. The other thing I'm going to say too is we want to make sure we answer questions. I really think the most valuable thing I can do while I'm here is address questions that folks have. So certainly we'll do that at the end, and also a couple of times along the way, I'll stop when we go over some of the more complex things and ask for questions. We have a microphone that'll be going around the room, so just fire away when we get to those times. A couple other things I always like to mention off the top. One is that I'm not an attorney, and I say that because a lot of people think, oh, you work at the FOI Commission, you must be an attorney, but my background is actually journalism. So I come at this from that perspective, having covered local communities. I've been at many local and municipal meetings, made record requests at the town level. So that's a little bit about my background, but I think that's important too because I imagine most of you on boards and commissions are not attorneys either. And with freedom of information, it can be difficult because all of a sudden you're a volunteer on the fire commission or a library board, and you're tasked with maybe having to interpret a law that you've never even heard of or never don't know very much about. And all of a sudden you're looking and you're saying, okay, what do we do for our agendas and our minutes? And somebody makes a records request, how long do we have to comply? And like with any law, it's not always so easy. Even if you go to the source material, if you go to the legislation and try to understand it. So this can be difficult. One of the important things I want to make sure you all get, this is also on the website too, but my email, my phone number, the office is available if you have questions. Certainly you also have local resources, a town attorney, your first selectman. FOI can be tricky. We want to make sure we do it right. It's important. And it's important too, if you have questions, that's okay. You can always go to somebody with a question. I often, talk to people on the phone all day when I'm not doing this, and there are times when we have a 5-minute conversation and it can save a huge headache because somebody just doesn't know one little part of the law, or they're not sure about something. And a lot of times these things can be difficult too because you may be up against time pressure. You've got to have a meeting tomorrow night, you're doing the agenda, you're moving fast, you're scheduling special meetings, whatever it may be. It's important that you conduct the business of the town, but it's also important that we conduct it according to FOI. And I hope after we go through the presentation tonight, you realize that FOI is not an impediment to the work that you all do, and that you understand the basics. So you know what you need to do to run your meetings effectively in accordance with FOI. But again, you're still getting that business done. It's not something that's taking up so much energy and so much time that you find yourself not having the time to do all the other important work that you all do. So another sort of starting point that I find is helpful is if we talk just very briefly about history of the Freedom of Information Act. So if you do not know, this is a law that goes back to 1975. And I think that's important for a couple of points. One, we're coming up on the 50th anniversary of the law next year, and two, the technology has evolved far faster than the Freedom of Information Act. So there are pain points, I like to say, where the law has really not kept up with modern technology. There have been some things that have been changed. There's provisions now about remote meetings, but there are things that can be frustrating or difficult, partly because we're dealing with a law that was passed in 1975 and it hasn't always been modified to deal with the world that we live in today. Imagine that this law was created at a time when there was no email, there were no computers, there was not digital information. Today, town halls have tens of thousands of digital records that people can request under FOI, which in terms of open government is great, but also in terms of processing FOI can be difficult too. And it also leads to new questions about meetings and emerging technologies and Zoom and Microsoft Teams. So we'll go over some of that. But I think to get us in the right thinking, you see up there the preamble of the Freedom of Information Act. I'm not going to read it, but essentially when this law was created, it was really about opening up our government to the citizens. The citizens are the people that we represent. If you're on a board or commission, you're elected or you're appointed, we're doing the work of the town. If you're a town employee, people that live in town are paying our salary. The government is supposed to be representative of the people, and that's really kind of the foundational piece of the Freedom of Information Act. El Grasso was the champion of FOI when it was passed in 1975, and it was really a post-Watergate reform. Across the country, we saw a lot of different states that were adopting the sunshine laws or open records laws. But what makes Connecticut different is that we have a Freedom of Information Commission. In some other states, they may have an open records law, but if you make a records request, or they have an open meetings law, but if you're denied access to a meeting, you have to hire an attorney, you have to go to court, you have to file a lawsuit. It can be a complex and expensive endeavor that a lot of people are not going to pursue. In Connecticut, we have a Freedom of Information Commission. There's no filing fee. So if somebody believes that the open government law has been violated, whether it's issues with public meeting, or it's an issue with a records request. Records request has been denied, the records haven't been given over in a prompt fashion, anything like that, they can file a complaint at no cost with our commission. And we have attorneys that do all the investigating. That's the only thing our agency does. We have about 13 or 14 staff members, and we get about 600, 700 complaints a year. We're very busy. I also like to say through these training sessions, because we don't need any more complaints. We're happy with the amount that we have. But it's important to know a little bit about the commission, because that's another reason that it's really important that we do all this. It's the law, we want to follow the law, we support an open government, but practically speaking, you don't want to find yourself in a situation where somebody files a complaint against your board or commission, and then maybe you're having to go to hearings in Hartford, and spending time and resources and all, some energy that could be going to the work that you're doing on the board, for an FOI complaint, maybe over something that was, not due to lack of knowledge, and that's really why we work through education. In some cases, if there are, the commission believes that things are really being done in a more malfeasance, we can issue fines. If we find a violation, we can order people to attend training sessions like this. In a records case, we can order the production of records. So the commission does have some power, to enforce FOI, but really primarily, I like to think we work through education, and we want people to know what the law is, to know the parameters of it, to know why it's important, and to know what they need to do when it comes to meetings and when it comes to records requests. So the first point on there, we already touched on that. There's basically two parts of the law that we'll go through tonight, so meetings and records. And we'll make sure we stop along the way, as I said, with people have questions. A couple other basics on there, what the law covers and what the law doesn't cover. I think that's also important to know, because I get a lot of questions about things that are up there on that slide. So FOI, in terms of records requests, it's really sharing the records that the town has. It's not having folks who work for the town, or if you're on a board or commission, you're not creating new records or doing research or creating a document or a list or an Excel spreadsheet. It's really just sharing whatever you have. If you're on a board or commission, you have a meeting, there's a presentation that you get as part of that meeting, or the town planner sends out information to the Planning and Zoning Commission. That's what we're talking about when we talk about public records. We're not talking about research. We're not talking about making determinations, even answering questions. Sometimes that one is a surprise to people. It doesn't mean that if you're on a board or commission, you're not going to answer questions from people who live in town. I think most of us want to try to help people if they have a question about what's going on at a board or commission. But it's important to know what the law covers, because these are the types of things people can file a complaint about. What's up on there, people can't file a complaint if they ask you to do a research project for them and you say, look, I can't do it, I'm too busy. Or public comment, that's another one that comes up a lot. Public comment is really a decision by the board how they want to do that, or at the town level. In some places, towns have charters or ordinances that require them to have public comment at every meeting. But you're not denying anyone their rights under freedom of information. If you curtail public comment, or you require people to give their name and address for public comment, that's quite common. Or you tell people they can only comment on items on the agenda. Anything to do with public comment is not part of freedom of information. Freedom of information is really an access law, access to meetings and access to records of public agencies. In the commission, we talked about that. So really the commission is where people come. If they feel that there's been a violation, then our attorneys will do an investigation, come up with a proposed decision, and then parties will go to one of our commission meetings. Our commissioners, who are appointed by the legislature and the governor, are really the final decision makers. So we have staff who do the work, but then we have a commission that the decisions go to, and that's the body that makes the final decision. This next one, we don't really need to spend a lot of time on. Public agency, you'll hear me say that a lot. Essentially, a public agency is anything that's covered by FOI, whether it's a town department, a board, a commission, a committee, board of education. You're all connected to Suffield in some way, so all of you are the board or commission, or the town, all part of a public agency. But the one important thing, I think it's bolded up there. there that I do like to make note of is subcommittees, because this is sometimes where people will trip up. If you create a subcommittee of a board, so if you have a board and you create a subcommittee, or a board of selectmen creates whatever you call it, a working group, a task force, if it is an extension of a board or an extension of an office, it has to follow FOI as well. Essentially, you can't delegate away FOI, your FOI obligation. So if your board is covered by FOI, you can't say, well, we're going to create a little subcommittee and they're just going to do whatever they want, and since it's not our board, they're not covered by FOI. So again, if you have subcommittees, you want to make sure that that they're noticing their meetings, that the meetings are open to the public, that there's agendas, that there's minutes taken, and all that. There is some allowances, and we'll talk about this more in detail in a minute, for what I call homework between meetings. There are situations where members can do board work to some extent outside of board meetings, but it's really limited, and if it's a formal subcommittee that's been appointed and has a particular charge and all that kind of stuff, it's probably something that's going to be subject to FOI, so you need to make sure that you're following all the rules that are required for meetings. So with that said, we'll start off with meetings, and I think the first most important thing we look at with meetings is to look at the definition of a public meeting. And I say that because not every meeting that is public is a public meeting. We are here today. This meeting was noticed publicly on the website and everything. We may have members of boards and commissions here. This is not a public meeting in terms of FOI. So didn't need an agenda, didn't need to be noticed. Nobody has to take minutes, or anything like that. So you see up there the definition of a public meeting, and there's three things that I want to highlight. In my mind, there's really kind of three triggers that make something a public meeting. This is important because if it's a public meeting, then again, it needs to be noticed, open to the public, we need an agenda, and we need to take minutes after. So the first part you'll see in there, meeting means any hearing or other proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency. So if you don't know what a quorum is a voting majority of the board. So if you have a 7-member board, for example, 4 members would be your quorum. If you have a 5-member board, 3 members, and so on. A voting majority of your board is a quorum. And then the next thing I want to highlight too is any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment. So a meeting does not just have to be in person. There is such a thing as an illegal meeting over email, illegal meeting over text messaging, illegal meeting over Teams or Facebook or Zoom. The platform doesn't really matter. What matters is we have a quorum. They're either gathered or discussing. And then the last part, something that is that they have supervision, control, jurisdiction, or advisory power, and for shorthand, I call that board business. So if we have a quorum, they're either together electronically or in person, and they're discussing board business. If you have those three things going on, by definition, that is a meeting. So if that was happening in an email, you can't do that because that meeting is not open to the public. It's an email, right? The public can't come and look over your shoulder while you're emailing the board members. Same thing with text messages. Same thing with Facebook group chat. Anything where we have a quorum, they're gathered together and they're discussing board business, is a meeting under FOI. There are some exceptions to that we'll cover a little bit later, but those are really the ground rules. If you have those three things going on, I'd argue in most cases that is a public meeting. The number one question that I get when I talk about that is usually, email. What can we do over email, right? It's the 21st century. We have to use email to communicate. And oftentimes, there are things that maybe have to go out to the whole board. So how do you draw the line, or what is okay versus what is not okay? I'll give my thoughts on that, and then if anyone has any questions on that point or anything that we've covered so far, we'd be happy to take those. So I think the key point on there is really discussion. So for example, if the clerk sends out the agenda to all the board members, but they're not discussing anything, that's not a meeting. What we don't want to have is a situation where, let's say it's Planning and Zoning Commission, the agenda goes out and people start responding in the email with their thoughts on the site plans. I think this one is great, I think this is bad, and there's a discussion starting to happen. Sometimes I'll see people where when they send things out like that, they'll say, please don't reply all, or sometimes they'll send things and they'll BCC people to try to prevent that. But basically, if you think about it, it's pretty basic. We don't want to be discussing things that are before the board before we get to that meeting. There are some things you can do, though, certainly. The meeting provision is not meant to stifle the sharing of information. One board member, got a letter from a constituent, hey, somebody wrote me a letter about they were unhappy with some project, I want to share it with you all just so you have it. That's not a meeting because you're not discussing anything. You're sharing the letter. People should not respond back and start discussing it. Anything that gets shared, if you want to have a discussion, you want to do that at the meeting. But there is some allowance there for sharing documents, like a letter, a newspaper article. Keeping your board members informed, about things is okay. But if people want to have a discussion or if that newspaper article touches off a point that someone wants to bring up at the meeting, really the right thing to do is to add that to the agenda at the subsequent meeting. Same thing goes with text messages. If somebody shares something in a text message, you don't want to start responding with anything substantive that would lead to a discussion about that item if it's something that's under your board's jurisdiction. So does anyone have any questions on that point about digital communications and meetings and kind of where the line is, or anybody have any examples they're concerned about or anything like that?
My name is Kevin Goff, 475 Thompsonville Road. At what point do emails become important? For instance, if I send out an email to my members polling on availability date, we've got three choices for a special meeting that's coming up. Are they able to respond to that email?
So something like that, if it's logistical in nature, I would say that's fine. Things like when the meeting is going to be, when the special meeting should be, if somebody's going to be late and they want to let the other board members know, or somebody says, hey, it's a hybrid meeting, I'm not feeling well, I want to Zoom in tonight. Anything logistical, I would say is okay because you're not getting into the business. I think that's where you cross the lines if people started talking about, what the subject of the special meeting was.
Okay.
One in the way back.
Hi, this is Kathy Harrington, 700 North Street. I just wanted to ask if you could cover what a caucus is and if you have a quorum.
Sure.
And whether that fits into the definition of a meeting.
So caucus is one of the exemptions to the meeting provision, and really it's the biggest one. So a couple things on caucus that are important to note. So if you have a caucus, even if your caucus is a quorum of the board, so if Republicans control board finance, let's say it's a 5-member board, there's 3 Republicans, the 3 Republicans, constitute a quorum, but if they're all of the same political party, they can gather in a caucus, it's not considered to be a meeting. The challenge with caucuses is that the law, other than saying what makes a caucus, doesn't define what you can discuss in a caucus. So you could have a situation, and this is where we run up against what I like to call the letter of the law versus the spirit of the law. I think in the spirit of FOI, people should not really be using caucus as a substitute for a meeting, but there's nothing that would prevent a majority of the board, if they're all of the same party, from talking about anything in caucus. They could talk about how they're going to vote, they could decide what changes to make to a budget, provided they're all members of the same political party. So it is a pretty big loophole, in terms of the rules that we typically follow. When we think about caucuses, in my view, really, when the law was created, I think that was something the General Assembly put in thinking of themselves. If you're familiar with the General Assembly, they caucus all the time, and I think when they were putting this law together, somebody probably said, hey, wait a second, does this mean our caucuses are now going to be open? So they put that in there. Obviously caucuses at the legislature are different than, caucuses at the local level, but because of that piece of the law, it's not an illegal meeting if everybody is of the same political party. Or the other thing I'll mention too with that is that you could have a situation where if you have a caucus made up of people of different affiliations, or you have 2 Republicans that are affiliated, in that case, there's a section of FOI that says legally you're supposed to register that caucus. So if you had a majority caucus of 2 Republicans and a Libertarian, they can caucus together if they register it and say we're the majority caucus for the term. But no, that's a good question and an important distinction. One thing I'll say on caucuses too is that the caucus provision allows you to meet, but it doesn't mean that the records you create, so if you have an email caucus or a text message caucus, those records would still be subject to FOI. So you could have an email caucus, but the records are not exempt. The caucus provision allows you to meet, but any records of that caucus, unless there's an exemption, such as attorney-client privilege or preliminary draft or something like that. Let's use our example. If the Republicans on the Board of Finance were emailing each other about changes to the budget, not in a legal meeting, but somebody could FOI those emails and they would probably need to be disclosed. Any other questions before we move on? Okay. So a couple other things up there too, just kind of some general ground rules for meetings. This one we've mentioned a few times, but anyone can attend a public meeting. They're not required to give their name and address. They're not required to sign a sign-in sheet or anything like that. You can set your own rules for public comment. Anyone can photograph, record, or broadcast a public meeting as long as they're not being disruptive. They can sit in the audience with their iPhone, they can sit in the audience with their camera, as long as they're doing it in a way where it's not impeding the proceedings. And then the last point on their agendas. Agendas must fairly apprise the public of what's to be discussed. We'll talk about this more in detail, but I just make a point to mention that because what I find sometimes is, you on your boards and commissions are really subject matter experts in whatever it is that you do, but you have to remember, the agendas are for public consumption. So when you're putting an agenda together, before you send it to the clerk, take 30 seconds and just pretend if I wasn't on this board or commission, would I understand, what's going on. I'll give you an example, something what not to do, and this was a case that, somebody filed a complaint, I'll tell you what happened. So there was a Board of Education in a town on the other side of the state where they had an agenda, and one of the items on the agenda was facilities update. They ended up voting at that meeting to close an elementary school. That was the facilities update. Predictably, people in town were sort of caught off guard and they were not happy, and they said, well, if you had put on there that you were going to close the Smith Lane School or something, we would have come, we would have had things to say. So somebody filed a complaint, and it was interesting, the complaint was filed, and then because of the public pushback, the Board of Education actually reversed course and voted to not close the elementary school, and they kept it open. Most places are not going to do that, but that's just an example of something where, you don't want to put something like that. If you're closing an elementary school, put on there that you're going to close the elementary school. You have public comment, people can come, they can comment. The agendas really need to fairly apprise the public of what's going to be discussed at the meeting. Email and meetings, we already covered this, but essentially, again, we don't want to be making decisions, we don't want to be taking votes over email. The meeting thing is okay, but we don't want to be voting on matters before the board or anything like that. So next we'll talk about the different types of meetings, and this is important because as we go through this, we'll also cover the requirements for meetings. I have some handouts that I'll make sure I put them out here at the end if people want to come and grab them and go over all this. But essentially, every meeting needs to have a notice and agenda, and then we need to take minutes afterward. So I find it helpful if you look at the two most common types of meetings, because the requirements are the same, but then there's some little nuances to it. So for regular meetings, every board or commission in town and subcommittee needs to file a regular meeting schedule with the town clerk at the start of the year. It basically just lays out when your regular meetings are going to be. We're going to meet the first Thursday of every month, the second Wednesday of every month, whatever it may be. So any meeting that is not on that regular meeting schedule is a special meeting. The name can be a little bit misleading sometimes because people think, special meeting, oh my God, something big's going on. Really all it means is just that there's been a change in schedule. There's been a snowstorm and you had to move your meeting from Tuesday to Thursday, or somebody's vacation is during that week in the summer and you move the meeting to a different point. The other change with special meetings besides the schedule, there's one other substantive change that will happen at a meeting, and that's that you can't add any items to the agenda at a special meeting if they weren't on the agenda that was filed 24 hours in advance of the meeting. When I started doing this, I actually never really knew about this or had seen it too much, but at a regular meeting when you have new business, you can add anything you want to the agenda. Even any new business board members have, they want to discuss, regular meeting, you can add it to the agenda, you can have a discussion, you can even take votes on things if they're added during new business. Sometimes that comes up if you have public comment. There's a lot of people that come out to talk about something. Your board may say, well, we want to make a decision on this, or we need to do something about this, or we want to discuss this item that wasn't on the agenda because all these people have brought it forward to us. Or, another common one, your board meets Monday night and something blows up over the weekend and you say, well, we need to do something about this. You get a regular meeting, you can add it to the agenda. Special meeting, you can't add anything to the agenda. So if you're doing special meeting agendas, If you have new business on your template or wherever it may be, you might as well just take new business off because you can't add any new business at a special meeting. So if you want to have a special meeting because it wasn't on our regular meeting schedule, we need to file a notice. So notice of a special meeting, also going to serve it, as the agenda. Basically, it's going to be one document. That needs to be filed at least 24 hours in advance, and that needs to be posted on the town website. Important when we talk about the filing of agendas and minutes and all these different things that we have to file. I talked about earlier how this is a law that is not really kept up with technology, and one of the parts, in my opinion, where that's pretty evident is with the filing. FOI requires a lot of filing to your town clerk. What goes on the website, it sort of depends on the circumstances, and like a special meeting notice, that doesn't go on the website, and certain other things maybe don't. So what I always try to tell people is, make sure you get, especially at the municipal level, the posting requirements are stricter at the state level, but at the municipal level, you want to make sure, first thing you do, you get the information to the clerk, before you go and worry about who's going to post it to the website or anything like that. It seems counterintuitive, but we had a case based on the law, where a situation where an agenda was posted online, it was never filed with the town clerk. That's an FOI violation. So you want to make sure that these agendas and notices and all these documents go to your town clerk. You want to also post them in a timely manner. I think again, the law in 1975 was contemplating people going to town halls to find out information about meetings. I think today most people are looking online, but we still have that filing requirement. So I just say that because it's really important. And in particular, too, you want to keep in mind things like holidays, days that town hall is closed. Just this week, I got a call from a town where somebody had, and this happens, we all make mistakes, somebody had forgotten it was Memorial Day, their board met on Tuesday, they never filed the agenda on Friday, the holiday, Tuesday morning, they realized it, they called me and they said the meeting's tonight, we never filed an agenda, and I had to tell them, if you move forward, that's an illegal meeting because it wasn't properly noticed. So, just another thing to be mindful of, make sure that these things get into the clerks or the whoever's the person that you're filing it to, and then get it on the website in a timely manner. But the first place you want to do is make sure that it gets filed with the clerk's office. So for regular meetings, the agenda again filed 24 hours in advance. Regular, special, agenda is always going to be 24 hours in advance. The next thing I want to talk about is minutes, and then after we go through this, I'll take another break. If folks have questions, I imagine some people might on minutes because it tends to be something people are curious about. So whether it's a regular meeting or special meeting, you'll see up there that there's a little bit of a distinction. Regular meeting minutes need to be filed within 7 calendar days, and special meeting minutes need to be filed within 7 business days. For the life of me, I don't know why they didn't just pick one or the other. It just, to me, it causes unnecessary confusion, but if you have a special meeting, you have a little bit extra time to do your minutes. The legal requirement for minutes, the only things that legally you have to have in your minutes are, who attended the meeting, what commissioners were present at the meeting. You don't have to list, other attendees. Some people do that, but what commissioners were present, and then any votes that were taken. You need to record the votes and make sure you record them in such a way that you can identify how each person voted. So passed 6-2, and Councilors Smith and Jones were the no's. So do it in a way where people can determine the vote. So the attendance, the votes, and if you have an executive session during the meeting, you need to list who attended the executive session. Those are the only 3 requirements for minutes. So if you put those 3 things in, those are legal minutes in terms of FOI. The most important thing with minutes is that you need to file them on time. And what I find a lot of times is people are well-meaning, and they want to have really detailed minutes, and they have a really great recording secretary who writes, 12-page single-spaced minutes that cover everything every commissioner said, and everyone loves it, but they don't get filed for 2 or 3 weeks. So the minutes need to be filed within 7 days. The other question I often get from people is they say, well, wait a minute, the Board of Selectmen doesn't meet again for 2 weeks. How can we file minutes if they haven't been reviewed by the board and they haven't been voted on? That process happens all across the state, but FOI doesn't distinguish. You need to have minutes filed within 7 days. So, a couple things I tell people, you could file, those minutes within 7 days, and you could call them draft minutes, or you could call them, put on there, subject to approval. And then, my view would be if there's going to be changes to the minutes, reflect that in the next 7 minutes. So if you have your, May Board of Selectmen meeting, the minutes get filed within 7 days, they go on the agenda for the June meeting for adoption. As if somebody makes a change, reflected in the June 7 set of minutes. You don't have to go back and repost every set of minutes once they've been approved. Some towns do that, but it's not required under FOI. So it's really the minutes you have within 7 days, as detailed as you can get them, is what I would say is the way to go. Because if they're late, it's a violation. It doesn't matter how great they are or circumstances. And I understand things happen. I've heard from some towns where it can be really difficult to find reporting secretaries. You have a great person and they retire. But every board has to have minutes. So if you don't have a recording secretary, you can't find someone to do it. A board member has to do it, or staff, or somebody has to do it. But the minutes need to be filed within 7 days. Interestingly enough, at the municipal level, there is not an online posting requirement. The statute is silent about when they need to be posted online. So, most cities and towns, I think, try to get the minutes up in a timely manner because people are looking for them. And also, if you post them online in a timely fashion, it will prevent people from calling you or emailing you and asking you for copies or coming in and asking for copies. But also important for citizens to know, the law is 7 days to be filed. So, I get people sometimes that will call me, the meeting was 2 weeks ago, the minutes are not online, should I file a complaint? I can tell them, wait a second, you should go to town hall, you should ask if they're there, because if they're at town hall, then, they're in compliance with FOI, maybe you're upset that they're not on the website, but that's not required by the law. So, that being said, if anyone has any questions about minutes or anything on their regular meeting versus special meeting or the notices or anything like that, I'll just take another pause to see if anyone has any questions.
So I have 2 questions. For the yays and the nays, when there's a vote,
I'm sorry?
when there's a vote,
Yes.
for the yays and the nays, is it supposed to name each board member, commission member, which way they voted?
So you don't have to name everyone, it's just as long as it's clear from, because you can rely on the attendance. Like when I do the minutes for our commission meetings, so we just list who was present, and then when I do the votes, I usually just do it past 6 to 3, the nays were identified with 3 people. So as long as somebody can tell, you don't have to list every single person and how they voted. And if it's unanimous, you could just say, pass unanimous.
Okay. I want to say that I read somewhere that maybe it's within the bylaws, so I'll just look into that.
Yeah, the other thing, sorry not to cut you off, the other thing sometimes that runs up against FOI is Robert's rules. There are different requirements for things that you have to do pursuant to Robert's rules, but none of that is enforceable by FOI. So, or it could be a board thing or a local bylaw or something like that. So there can be other things, but in terms of FOI, just as long as people can identify how a person voted.
Okay, and then the second question is, the minutes have to be filed within 7 days. Oftentimes, they go out to the board members, and the board member will send an email to the secretary. Oh, I observed that there's a mistake. Someone, was in by Zoom, or in varying degrees of a mistake. So, are there any rules as far as reposting them on the town website so that the correct version?
Yeah, so you could do that. It's not a requirement, and that's kind of a town decision. Like I did this training session in another town, and they told me, every time the board votes on the minutes, they go back and they repost them, which to me seems like a lot of extra work if there's not a significant change. But I would say it depends on whatever works for you. If there's a significant error, you probably want to correct that. If it's a minor typo or something like that, then maybe you just do like what I said, where you could address it in a future meeting or something like that. I think it would depend on the severity of the error and how you want to go about it. But either way would be fine. Any other questions on minutes? Okay. So the next thing that we'll cover very briefly is what's called an emergency meeting. So we don't see these too often, but an emergency meeting is a meeting that is unnoticed, and there's no public notice, there's no agenda, And as the name suggests, only in the event of an emergency. There's an emergency that's so dire that we need to act immediately. We can't wait 24 hours to schedule a special meeting. As you see up there, you can only consider emergency matters. If you have an emergency meeting, you file minutes within 72 hours, and those minutes do need to be posted on the website. People often ask, what is an emergency, what's not an emergency? You see some language up there from our Supreme Court. It's got to be something that's unexpected, demands immediate action. I unfortunately have a new example that I've been using. Up in northeastern Connecticut, about a month ago, there was a small town where the first selectman died unexpectedly in the middle of the night. And the other two selectmen had to have an emergency meeting the next morning, really to kind of figure out what was going to happen, who was going to be in charge, who was going to sign the payroll, did they have to contact someone at the state, all these important things that, understandably, they didn't want to wait 24 hours to address. They needed to figure out and get things in motion that very next morning. So, that was an example of something. Other examples of emergency meetings could be a weather emergency. Snowstorm is coming. There needs to be money moved around to hire more, contractors to plow the school driveway, or it could be COVID. We saw during COVID, people had emergency meetings because we had all these public health orders coming down from the state, and we making decisions about closing town buildings and closing schools, and a lot of this happened very quickly. So, what is not an emergency, what we don't want to see is, I gave that example earlier about the person who forgot to bring the agenda in with Memorial Day holiday. Some people have asked, well, what if we just move forward with the meeting and we just say it's an emergency meeting? Forgetting to file the agenda is not an emergency in terms of an emergency meeting. So if something like that happens, it can be frustrating, but my advice would be, as I told the person who called me on Tuesday, cancel that meeting and reschedule it for a day later in the week. So emergency meeting is a tool you can use. We hope you don't have to use it. You see up there a situation where in a town where they had an emergency meeting that the commission ruled was not an emergency, and that involved a personnel matter in their fire department. And what happened was there was a confrontation on Friday, and the board of selectmen felt like it was so important that they scheduled an emergency meeting for Saturday morning at town hall to discipline the employee that was involved, and the employee filed a complaint to the commission, and Superior Court and Supreme Court all agreed and said that was not something that needed to be dealt with immediately. They could have put the employee on paid leave or something like that while they looked into it, or scheduled a special meeting for the following week. But it's important that one of the reasons I put that in there is because in that case it involved one of the powers the commission has over meetings that we don't do too often. But another reason, yet another reason that we want to make sure we do all this correctly is it's possible the commission can nullify actions that were taken at an improper meeting. So if there's a meeting where it wasn't noticed properly, or people were denied attendance to the meeting or something like that, and there was an important vote that was taken, it's possible somebody could file a complaint, and then this could be months later, the commission could come in and could say, well, that decision that you made is nullified now because you did not, it was not truly a public meeting. There were people who couldn't attend. Another point that I'll make too, this comes up sometimes, particularly more in smaller towns, but obviously, when we have our meetings, maybe you have a regular place that you meet, you have a little conference room with, fits 20 or 30 people, and that works for most of your meetings. But if you have a situation where you're expecting a bigger turnout, you do need to be mindful of the room that you use, and I'll explain why. So, we have, by the door when we come in, we've got by order of the fire marshal, we can only have so many people in the room, and obviously we can't violate that. But we also have an FOI law that says people have the right to attend a public meeting. So what that means is, if you find yourself in a situation where there are so many people showing up that they can't physically get in the room, you need to adjourn the meeting, move it to a different location, reschedule it. You have to take some kind of action, because if people can't get in the room, even though obviously we can't exceed the fire code, their right under FOI is still being violated, and they can file a complaint. As an example, I grew up in the town of Chester, down the Connecticut River, small town, about 4,000 people. Probably now, 10 or 12 years ago, somebody had petitioned our Planning and Zoning Commission to put a regulation in that would have outlawed people from having roosters in their yards. And people, I'm not sure why, got really upset by this. I mean, Chester's a small town, but I never thought of it as like a big farm town, but suddenly everybody had rooster stickers on their cars. There was this whole thing, and it was all about saving the roosters. And so, they had a meeting at the town hall, in the biggest room in town hall, and so many people came that they had to adjourn the meeting, they had to move it to our elementary school gym, because that was the only place big enough that they could set out all the chairs for all the people to sit. So if you have a situation like that, or you're expecting a lot of people to come out to something, and you normally meet in a small little conference room, you may want to consider, moving to a larger room for that meeting if you think there's going to be a lot of turnover. Minutes, we already covered, I think, everything on there, except the last point, and I'll mention this too when we talk about electronic meetings, but even if you record a meeting, you still need to do minutes. So you always do minutes. If you record your meetings, it may be that the minutes are going to be shorter because there's a video recording people can rely on, but minutes are not a substitute for, video recording is not a substitute for minutes.
Question for you.
Yes.
If there is a video recording, does that have to be preserved in some way?
So that's a good question, and this is one I get to dodge a little bit. So there are records retention laws in terms of how long you have to keep records at the state and municipal level. So a meeting recording, if it's a meeting you have to record under FOI, our law says it has to remain on your website for at least 45 days. But after that point, FOI doesn't say anything about it. So the Office of the Public Records Administrator at the Connecticut State Library, if you go on their website, they have what they call a municipal records retention schedule, and it talks about all the different records and how long you have to keep them, emails and financial documents and things like that. So with a video, I'll just say I don't really know other than our law says 45 days. So it has to be up for 45 days if it's required by FOI, but after that point, there's nothing in FOI that talks about how long you have to keep them.
Is there a distinction between video and audio?
So there's no law, there's no meetings under FOI that you have to audio record, and the only meetings under FOI you have to record are entirely Zoom meetings. So if you had a full virtual meeting, then under our law, and I think that's up there, right? Yeah. So that if there's a fully virtual meeting, then you do have to record that meeting and then post the recording on your website within 7 days, and then leave it up for at least 45 days. If it was an in-person meeting, like if this was a Board of Selectmen meeting or something like that, you wouldn't have to record it. If it's a hybrid meeting, you're not required to record it. A lot of towns I've found record most of their meetings. I think because people kind of look for that now, or they invested in equipment, maybe during COVID to record meetings. So a lot of towns do more than that, but the minimum is if you have an online-only meeting, you need to make sure that you record that. So next thing we'll cover, electronic and remote meetings. Important to know that whether or not you have an electronic component to a meeting, a Zoom or Teams or WebEx or whatever it is, whether or not you do that is really a decision that the board gets to make. So it's a board-by-board decision, and even more than that, it's a meeting-by-meeting decision. So, just because one of your meetings, normally you meet in hybrid fashion doesn't mean that you couldn't decide one day, well, for our meeting in September, we want to, we're the Board of Education, and a new middle school just opened, we want to move the meeting and have it in the middle school so people can come and see the place. So it's a meeting-by-meeting decision. But if you have one of your regular meetings and you want to have it either fully virtual or you want to have a hybrid where there's a Zoom link and an in-person, if either of those are the case, then you need to have that link available 48 hours in advance. There needs to be a notice on the website 48 hours before that hybrid or Zoom meeting that says, the regular meeting of the Board of Fire Commissioners on Tuesday, July 28th is going to be held, hybrid, at the auditorium and Zoom, and here's the link. The agenda is still 24 hours in advance, so the agendas are not 48, the agendas are still 24, but essentially you need to have some other information on your website with the link and the access instructions. The reason for that is that there are provisions, and I won't go into all of them. If you're really interested in remote meetings, go on our website. We have what's called our Remote Meetings Primer. It really goes into a lot of detail about all these different things. But there are provisions in the FOI law that allow for a situation if somebody doesn't have the correct technology or they have bad internet or something like that, and they're concerned about their access to a remote meeting, they can call the town hall, and the town has to make some kind of accommodation. It could be that they say you can go watch in the library, or it could be that there's a place in town hall that they could go, or something like that. So that's the reason for that 48-hour requirement, is to give people time to do that if necessary. It gets confusing though, because you can still have a special electronic meeting, and that's always going to be 24-hour notice because it's a special meeting. So the 48-hour notification is only at your regular meetings. Meeting recordings, we just covered that, but the only meetings that you have to record are online-only meetings. Those need to be recorded, posted on your website within 7 days, and left up there for at least 45 days. You still do minutes. Minutes are required, the permanent record for the town. So again, even if you record the meeting, you do the minutes, but maybe they're going to be briefer. I had a conversation with one town where, I think the issue they were running into was, with public comment and how many people came out, and we have to record everything that they said, and how do we do all that? My suggestion to them was, well, if you have a video, you could always link to the video, or, you could sum up public comment, and then if people want to view all that was said, they could go and they could view the video, and they could see every speaker, and everything that they said. The last point on there, about how you can kick people out if they're being disruptive, obviously that's the same rules as an in-person meeting. You have a right to run an orderly meeting, whether it's in person or it's on electronic equipment. But I think it's important to mention here because, we saw this early on in COVID when we were all learning Zoom, where you have Zoom bombing. You'd be in your board of finance meeting or whatever it is, and then all of a sudden, the screen gets taken over and there's all kinds of crazy music and videos playing and things like that. Recently in another city, I had a situation where, I think it was like people were coming in for public comment, but they had their cameras off and they were putting up fake names, and then when it went to them, they were yelling all kinds of inappropriate things. If you ever find a situation like that where somebody in a digital meeting is being disruptive, you can mute them, you can kick them out. The same rules apply. You're not violating anyone's rights if they're interrupting your meeting, or even if somebody leaves their microphone open and they're blasting music and you guys can't hear each other talk, you can click the mute button or whatever you need to do. There's even a provision where if things get so bad that the meeting needs to be rebooted, you can even do that as long as you say what you're doing and you resume it at the same link if that becomes necessary. So as I said, there's a lot of detailed information about remote meetings on that primer on our website. But if anyone has any questions on remote meetings, what's appropriate, what's not appropriate, we'd be happy to take those.
What is the recommendation if, let's say, we have a regular meeting scheduled for Tuesday? The agenda's out, it's in person. There's a snowstorm coming, don't know which way it's gonna go. You get to Tuesday morning, it needs to switch to online only. Are you then required to cancel the regular meeting? You can't just change it to an online meeting?
Yeah, so if it's the morning of the meeting, then you would not be able to change it because of that 48-hour requirement. So, if it was 48 hours out, you could decide, okay, we normally meet in person, we're going to make this meeting, a online only because we're not sure of what's going to happen. But you could not make that decision the morning of the meeting. So if it was the morning of the meeting, you couldn't meet in person, you'd have to cancel it and schedule a special meeting.
Okay, thank you.
Any other questions about virtual meetings? One thing I'll mention, because this comes up sometimes, I forgot to say it, is there's nothing in the virtual meeting law that prohibits you from having a situation where members of a board or commission are going to Zoom into an in-person meeting. So if you're, let's say Board of Finance again, they meet in person at Town Hall, one of the members is not feeling well, and one of the members is homesick or on vacation or whatever it is, members can always participate remotely in an in-person meeting. Sometimes people say, hey, it doesn't really seem like it's fair, if we have a Zoom, should we open it up to everybody? What I would say is if you think about, before we ever knew what Zoom was, you might have meetings where people would call in on a speakerphone, right? Commissioner Harris is calling in from sunny Florida to our planning and zoning meeting or something like that. So regardless of the technology, whether it's a speakerphone, whether it's Zoom, whether it's, I even had situations where they put the person on a cell phone and put them on speaker and they just put them there. As long as people can hear who the person is and they identify themselves when they're speaking and voting, any commissioner can participate remotely even if it's an in-person meeting. Okay, so electronic meetings, as I said, the most important thing to know on that is that it's your decision if you want to have them or not. If you do want to have them, there's some additional rules that come with that, really to make sure that we have the same level of access, whether it's an in-person meeting or an electronic meeting. So now we come to executive session, and in my opinion, I think this is one of the hardest things in terms of meetings, really because it requires more judgment than some of these other things. An agenda is either going to be filed on time or not. Minutes are going to be in on time or not. But with executive session, there's a little bit more, room for interpretation about, what is a personnel matter, what is a pending claim or litigation, what's appropriate, what's not appropriate, what do we put on the agenda, how much information do we have to share, who can go into executive session. So we'll cover all that, and then I'll also ask for questions too, because important to know in terms of complaints that we get far more complaints about records, which we'll cover in the second half, the records requests. We get more complaints about that. But I would say of the meetings complaints we get, I think executive session is probably the number one area where we get complaints about. One reason of that is because it's part of a meeting that's closed to the public. They can't go in, so people are naturally curious about what happened. And if they think it wasn't proper, they may file a complaint to try to find out what happened. And the other thing too, like I said, it's a little bit trickier because there is some interpretation. So the way I look at it is, if you look at the FOI statute, there's really 5 reasons, and the statute is specific, to these 5 reasons. Executive session is not meant to be, let's talk about something before we roll it out publicly, or, this is controversial and we want to avoid public blowback, or we want to have a kind of a pre-meeting to talk about something before we, that's not really the purpose of executive session. Executive session is for the purpose of discussing specific items, and in most cases, I think you'll agree that the reason we have executive session is to protect the interests of the town. Look at number 2 on there, pending claims or litigation. If that wasn't permitted, if it wasn't permitted for boards or commissions to go into executive session to talk about pending claims or litigation, they would have to talk about legal strategy out in open session. The person who is suing the town could be sitting in the audience and listening to them talk about their trial strategy or what witnesses they want to call or proposed settlement or things like that. So a lot of this makes a lot of sense. Security matters, the same thing. If it's a security matter that you feel a public discussion would, pose a risk. We saw this a lot, unfortunately, after Sandy Hook. Schools were reevaluating their security measures. Maybe they were spending money. There were some state grants that went out to do different upgrades and things like that. It makes sense, again, that we want to have the discussion of the specifics of that system in a closed session. You're not voting on anything in executive session. You have to take a public vote. So if the town is going to spend money on a school security system, there needs to be a public vote at some point. But they don't need to discuss, publicly, how many cameras they're going to put in, or where they're going to put panic buttons, or bulletproof glass, or things like that. The details of that security system can remain confidential. So the other reasons for executive session, personnel matters. The important thing with a personnel matter executive session to know is that the person who is being discussed needs to be notified, and then they can request to have that discussion in open session. So if you had an executive session to discuss a personnel matter, let's say it was potentially disciplining an employee in the Public Works Department, you would have to notify that Public Works Department, foreman, whoever it is, and say, hey, we're having an executive session on the Board of Selectmen to talk about what happened last week. And then that person's right under FOI is to say, no, I don't want you going into executive session. If you're going to talk about what you think I did or what I didn't do or whatever you have to say, I want you to do it in an open session so my family can go, my coworkers can be there. Whatever you have to say about me, I want you to say it in a public session. Sometimes people think that if you're the subject of a personnel matter, executive session, you have the right to attend, and that's not the case. If you waive your right to an open hearing, or if the person that you're bringing, that you notify says, I don't want an open hearing, then whether or not they come into the executive session is at the discretion of the board. The attendees of an executive session is anyone the board wants in there, but it's important to note too that the people going into the executive session should be there participating. They're giving testimony, they're giving their opinion, they're giving their expertise. You're bringing in, your town attorney to ask them legal questions. You're bringing in, your school superintendent to discuss a personnel matter at the Board of Education. They need to be actively participating in that executive session. You want to avoid what you see up there, what we call creating a second audience. You don't want to bring in people who are just going to sit in the back of the room in the executive session and they're just listening and they're not participating, because then you're privileging those folks. They got to attend the executive session, maybe over a citizen or someone else who wanted to be there. So personnel matters, pending claims or litigation, I touched on that one. The important thing with that is, this is related to a lawsuit or something that's actually been filed. It's not meant to be, an ad hoc discussion about legal matters. Security at the municipal level, you can discuss the sale or lease of property in an executive session, before you make a purchase or sign a lease. If you feel that publicity would impact the price point, if there's concern that well, if people find out the town is interested in purchasing this parcel, someone else is going to come along and bid up the price. You could talk about that in an executive session. Again, all this before you make a vote. And then the last one is you can discuss any records that are exempt from FOI in an executive session. So that could be things like a legal memo protected by attorney-client privilege. It could be a draft document. There's an exemption for draft documents. There's also a time-limited exemption for bids and responses to RFPs. So if your board or commission goes out to bid for something and you get the bids back, before you award a contract, you could have an executive session to review those bids. Once you award a contract, then the discussion would have to happen in public. The records would need to be disclosed if someone made a records request. But before you sign a contract, you could review those bids in executive session and discuss them. One last thing on executive session that's important to note is when you are preparing an agenda, if you're having an executive session, it's on the agenda, you want to be a little bit more specific than just one of these reasons like personnel matter or pending claims or litigation. The way to think about it is the executive session is off limits to the public, but they still need to know the topic that you're talking about. So if the situation is a personnel matter in the fire department, you should put something like executive session to discuss personnel matters in the fire department, or executive session to discuss the performance of a firefighter, executive session to evaluate the fire chief, something like that. You don't necessarily have to name the individual employee, but it needs to be something more than just personnel, or something more than just legal matters, or even security. Again, we don't want to reveal the security strategy, but you have to say something like discussion of proposed security upgrades to Suffield Middle School, right? That doesn't tell anybody anything other than the building that we're talking about. So with that being said, if anyone has any questions on executive session.
Actually, I have a question. I'm a recording secretary on a number of boards, and the one where it says personnel matters, that's inclusive of only people that are actually personnel, correct? That is not someone who may be considered for a position. Personnel to me means someone that works here.
Yeah, so it either needs to be, it could be a job candidate. Like if somebody, you can't have a personnel executive session for the purposes of hiring. So if somebody has applied for a position with the town, you could interview that person in an executive session. But it should not be for discussing things like job descriptions or, what we want in a candidate or kind of sort of preliminary discussions that might precede a job search. It really needs to be, to your point, about a person. There needs to be a person that has been notified that is either there or not there. It's not, sort of the issues of personnel like staffing or job descriptions or things like that. And then the other thing too I'll mention with that, because it comes up sometimes, is that it could also be a personnel matter of the board. Sometimes we see this where you have a vacancy on the board and you're appointing someone to fill it. The board could have an executive session to interview people for that that position on the board, or this was an unfortunate one, but there was a situation where somebody called me, I think the end of last year, they were discussing, taking a censure or something against a fellow board member. They asked, well, can we do that in executive session? And I said, well, if you really want to, you could, because it's a personnel matter of the board. So it's either the board members or a town employee or a job applicant.
One other question. The job applicant then has the right to be there?
Not the right to be there, but based on the statute, you have to notify them. So if you had, let's say you had a situation where you're hiring for a fire chief and you have 3 finalists or something like that, pursuant to the statute, basically, if you read the part about personnel matters, it says if you're having a personnel matters executive session, you have to notify the person. So even though they don't work for the town, you have to tell the people, you're a finalist, we're going to take up your application at the Monday Board of Selectmen meeting. You don't have to invite them. You could if you wanted to.
Okay, so just to be clear, they do not automatically get the right to be there.
No, they automatically get the right to have it in open session if they want to. That's the right under FOI. In most cases, for good reason, people usually don't want to do their job interviews in a public meeting. But that would be what they don't get the right to be there. So if you are discussing applicants, you don't have to have them there with you in the executive session.
Okay, thanks.
I'm loud enough.
The board cannot. So if the person says, I want to have this discussion in open session, then the board has to have it in open session. If they move forward with the executive session anyway, the person could file a complaint and they would, they would be in violation. So, as I said, sometimes that happens in disciplinary issues or, the other thing to know with all this with executive session is that you're not required to go into executive session to discuss any of this. So the board could just decide we're going to do a personnel matter in public session, and sometimes you'll see that with like an evaluation of a town manager. If everyone really likes the person, they just say, hey, let's just do it in public session. Nobody cares. So they don't even go down that road. But if you go down that road with the executive session, notify the person, and they say no, then you have to stop. Any other questions on executive session? You got one over there.
I've always understood that any negotiations could be discussed in executive session, not just for purchase or sale of property, or for sale of property, but for purchase of property, labor contract negotiations, any of those things could be.
So, it wouldn't be all negotiations with labor contracts. That slide is I think the next one coming up. Under FOI, if it's a strategy session regarding labor contracts, it's actually not considered a meeting. So you could do that outside of a meeting if you wanted to. You could have the Board of Selectmen meet with the union president as a full board and talk about the contract or meet to talk about their strategy or anything like that. Collective bargaining discussions can happen outside of meetings. There could be other instances where you could have negotiations outside of a public meeting, but it wouldn't be in all circumstances. It would kind of depend on what the situation was. Any other executive session questions? Okay. So this is, I'd like to say, after we talked about all that, and we already jumped to the gun with the caucus, so I'm glad we covered that one. But there are situations where, everything that I just said you can ignore if it's one of these situations. So caucuses, we covered at length. Strategy or negotiations related to collective bargaining, we just mentioned that one. Other instances that are not public meetings under FOI, any board can create a personnel search committee for an executive level employee. So a board of selectmen. I know you don't have one here, but if you had a town manager, for example, a board of selectmen could create a search committee to look for a town manager, and then that search committee, regardless of who's on it, can do its search committee work outside of public meetings. They could meet with candidates, they could meet with the search consultant, they could review resumes, they could do any of that because the recommendation they make is going to have to come back to the board for a vote. So there will be some public process. We see that a lot with school boards too, with superintendents. They'll make a search committee, do the search committee work, and then make some recommendations to the board, and then the board takes it up in the normal course of business. Staff meetings are not meetings under FOI, so meeting with staff of a public agency is not a public meeting. Meetings are our boards and our commissions and the like. And then the last one up there is what's called a chancellor social meeting. And what that means is that if you have a situation where you have a quorum of a board gathered together, but they're not there for the purposes of discussing board business. They're at a town event, they're at a football game, they're at the mall shopping together, they're at a restaurant, but wherever they are, if they're not discussing board business, it doesn't, it's not a meeting under FOI. And that's really the important thing is, if you're, particularly in smaller towns, you may be friendly with your board members outside of the board business that you do. You guys may be part of the same, different social circles or clubs, or your kids might go to school together. So you may find yourself, particularly with a small board, a quorum is only 2 members, right? You could have a situation where, you have a quorum of a board sitting on the bleachers at the football game together, but you don't want to be talking about board business in those situations. You don't want to be, talking about the budget or talking about what's coming up at the meeting or how you're going to vote on something or anything like that. You want to try to avoid what I call a parking lot meeting, which is where, we have our public meeting, the meeting ends, we all go out to the parking lot and everyone's standing around and chit-chatting. And, most of the time, you're probably blowing off steam or talking about your summer vacations or, things that aren't a concern. But you need to be careful and you want to really avoid talking about board business. Imagine, if you will, for a second, a situation where, it's a planning and zoning meeting and there's a public hearing on something and there's a lot of feedback and they don't vote on the application that night. They table it and they say, okay, we'll come back in 2 weeks. The developer's walking out and sees the planning and zoning commission standing in the parking lot and thinks he hears them say something about his project. He could file a complaint with us and say, look, I think they were having an illegal meeting. They were talking about, my project or, out in the parking lot. So We want to just be mindful, again, when we're discussing board business, we want to be doing that in public. So the next part it will cover is records and records requests, but I also just want to pause again if anyone has any questions at all about meetings, anything we didn't cover, anything that was unclear, anything at all. Okay, so now we'll get to the records piece of FOI, which, interestingly enough, as I said, we get more complaints about this, but I find a lot of times at the municipal level, people are really interested in the meetings part, it varies. So we'll go through the records piece of it, but I'll also be sure to focus on some things that I think are important for you all to know as members of boards and commissions. So like a meeting, with a meeting, it's important that we look at the definition of a public record. And, I'm not going to read it. You see it up there on the screen. It's really quite broad. And essentially, any information that the town has that relates to the conduct of the public's business. And that's really the important determining factor is, it's a public record if it deals with the conduct of the public's business. It doesn't matter if it was created by the town, even if the town receives information, that becomes a public record. If a citizen writes a letter to a town or communicates with the town in some way, applies for a building permit, whatever it is, those are all public records. Anything that the town uses or receives or has or can get through law or through a contract. And then the other important part is that, except as otherwise provided by any federal law or state statute, all records maintained or kept on file by any public agency, on and on, shall be public records. So what that part means is that if it deals with public business, it's a public record. And unless there's either an exemption within our law, so we'll go through some of those, or there is another state or federal law that says something is off limits or can't be disclosed or is confidential. The example I give with that recently is if you've ever gone to the DMV recently and gotten your license renewed, they take your picture in front of the blue screen. The state has all those photographs, but I can't go FOI those because there's a motor vehicle statute that says those photographs are only available for certain people, for certain purposes. All that information they collect when we get our licenses, somebody can't go and FOI that and get a copy of your driver's license. But if there's not a law, if there's not an exemption within FOI or there's not another law, then people have the right to obtain copies of that record, or they can come to public offices and inspect records. Important thing to know as boards and commissions is that the device the record exists on does not matter. And so what that means is, I imagine all of you on boards and commissions are not, the town's not buying you all cell phones to do the work that you do. You're using your own phones. So if you're texting about board business, if you're sending emails about board business, even if it's from a Gmail or a Yahoo or something like that, the device or the account, or if you create something on a work computer, your home computer, if it relates to the public's business, it's a public record. So it doesn't mean that a requester gets to go looking through your cell phone and looking at all your text messages, but it means that somebody could make a request for something like all the text messages between the planning and zoning chairman and the town planner about a certain topic. And if there were any, if they had been discussing board business over text message, there's nothing wrong with that. If it's just the planner and the one commissioner, it's not an illegal meeting. They can talk about town business on a text message. But if somebody makes a request, those messages would need to be provided unless there was another exemption. But it would be the person who has the phone who would do it. So the planning and zoning chairman would have to go through his or her phone and pull out responsive messages and provide those if a request was made. Again, only things dealing with the conduct of the public's business. So if they're friendly in other ways, or their kids are on the same soccer team or things like that, it's not those records. It doesn't mean that all of a sudden your cell phone becomes open for public inspection. It just means that if you use a personal device to do your town business, the records of your town business are still public records, regardless of where they exist. Anyone have any questions on any of that? Okay. So now we're going to go kind of over an overview of a little bit about records requests and the different obligations. The next slide will cover how the timeliness of responding to records requests. That's an important thing to note. But a couple of sort of ground rules here to know. So, people can inspect records at no cost. This is really more of a situation that would happen if you're a town employee, but just know that people can come into town offices, they can ask to see public records. Nobody's required to provide them with immediate access to public records. The standard under FOI is promptness. We always want to be prompt in responding to FOI requests. But people can come in during regular office hours and they can ask to review public records. If people want copies of public records, they do have to put something in writing. So if you're on a board or commission and somebody comes up to you after the meeting and says, hey, that presentation you had was really interesting, can I have a copy? You are free to tell them, please send me an email, send the town planner an email. If they want a copy of the record, then you can put something in writing. In terms of fees for digital records, and this is a more of a pain point when I do these with town staff, but there are no fees associated with copies of electronic records. There are a few cases where that's not true, but in most cases, if it's things like emails or PDFs or a report or documents, anything that's readily available on a computer, somebody can ask for a digital copy of that. There's no charge for that. If somebody wants paper copies of records, they can be charged 50 cents per page at the municipal level. You can also charge for a digital storage device if that's necessary to fulfill a request of digital records. And if the cost of the request is going to exceed $10, the town can ask for the money up front. A couple other things on digital versus paper. You're not required to scan anything in response to an FOI request. So if somebody requests something and the town only has it in paper, then they can provide the person with the paper and they can charge them. If it's digital and the person wants the digital, they have to give it to them at no cost and give them a digital copy. There's no requirement people use a specific form to make an FOI request. By law, any written request for government records is an FOI request. So, if somebody sends an email and you're on a commission and they say, hey, I would like a copy of the report that you guys had in the packet last night, that's an FOI request. They don't have to state for your information, they don't have to cite the statute or anything like that. Any written request for a public record is an FOI request. And this one we already touched on, but you don't have to do research or create records that don't already exist. So if somebody asks you, for a list or a report or something like that, and you don't have it, you don't have to go through all these other records and create a list in response to that request. Really, you're just sharing whatever you have as you have it in the format that you use it in. You don't have to reformat things for people or change, the columns on an Excel and add things or do anything like that. You're not manipulating any of the records or anything like that. You're really just sharing whatever it is that you have. Any questions on any of that? So this is a common question that I get from both requesters and also from people who work in town halls. How long do we have to comply with an FOI request? If someone makes a request, what is the standard? So there is one specific time frame, and this is really important that everyone is aware of this, is that you have to acknowledge a records request within 4 business days. So even if you're on the board or commission and you're not the chairman and maybe you think the town planner should be the one to handle it or whatever it may be, if you get a record request, you need to make sure that that person who made the request gets an acknowledgement back within 4 business days. It could be you, it could be a town staff member, town attorney, however the town wants to do it is fine. But you need to respond to them. That response doesn't really need to be very detailed. It could just be we received it. Again, talking about a dated law, the reason that was put in there is in 1975, everyone was mailing FOI requests. So if that wasn't in there, if you didn't get a letter back, you had no way of knowing whether they got the request or not, I guess, unless you kept calling them up and trying to see if they would tell you. So you have to acknowledge the records request within 4 business days. Today, again, you just send an email back, you got it, and you're all set. And then you need to fulfill the records request promptly. In some ways, when I started doing these presentations, I thought, gee, wouldn't it be easier if we just had a deadline? And some people have agreed with that. Look, if it was a month or 2 months or 90 days, or if there was a time frame we had to do it by, we would know how long it takes and we would avoid all these questions. But I think the legislature smartly, when they put the law together, recognized that requests are going to vary widely from one to the next. Part of the reason of that is there's no limit on how much information somebody can ask for under FOI, other than if the town has it or not. So if the town has it, somebody can FOI it. Again, there could be exemptions, there could be determination is it public record or not. Sometimes that happens. But regardless of if it's 10 years old or 20 years old, or if it's in the town hall, or if it's in the annex, or it's in the basement or the attic, it doesn't matter where the records are. People can make really large requests, but obviously a request that's going to require someone to trek across town to 3 different buildings is going to take longer than one where somebody is just going to drag a file off their computer and send it in an email. So we have this promptness standard, and you see up there the different things, the different factors that the commission looks at. So if somebody were to make an FOI request to the town of Suffield and file what we call a promptness complaint, they allege the town is not being prompt or not following the promptness provision, those are things we would look at. how large is the request, the volume of records requested, the amount of personnel time necessary to comply with the request. If the requester makes it known that they need the records for a certain purpose or by a certain deadline, doesn't mean that if you don't get it to the person by the deadline that you're in violation, but it's just one of the factors that we look at. If somebody seems like they have a real urgent need for a record, it may be just something you want to consider when you're looking at how long it's going to take to fulfill the FOI request. People can make large requests. They're entitled to do that, but I think on the requester end of things, they should understand that large, complex requests can take quite a while, and you can take a long time and still be prompt. We had a case with the state police, I think 2 years ago now, where somebody asked for a very large investigatory file, I think it was like a multiple homicide, it was this thick, there were all these different exemptions, law enforcement records, there were a lot of things that they can withhold. So it took the police over a year to complete the request. And the person filed a complaint, and we said they were still prompt because of all the factors as to how complicated it was, how many pages there were. It was still prompt. That doesn't mean that you're going to get a year to complete every FOI request, but really it's on a case-by-case basis, depending on the complexity, depending on all these other different factors. A couple tips that I'll give. One is that if somebody makes a very large FOI request, you can always ask them to narrow the scope of their request. If somebody asks for the last 5 years worth of records about something, you could always go to the requester and say, well, we have the last 2 years available digitally. I could do that in 2 days and give you those. Would that answer what you're looking for? How would you get that? And let me know if you still need more. I think dialogue with an FOI requester is really important. Too often, I think people get an FOI request and they start to get their back up a little bit and they get adversarial and they wonder who's this person, what are they asking for this for, what do they want to do with this. The new thing I've run into from a lot of towns that people are worried about, oh my God, they're going to put it on Facebook. The law doesn't contemplate what someone wants the record for, what they're going to do with it when they get it, if it's politically motivated or not, or if you disagree with what their intentions are. None of that really matters. What matters is you look at the request, is it for public records or not? Do you have the records, first of all? Is it something you have or not? Obviously, if you don't have the information, you don't have to track it down somewhere else. If someone asks the town planner for something and it's a police department record, they could say, go to the police department. But the motive of the requester is really not something that should be a factor. You can always ask the person, why do you want this? But they don't have to answer you. So, you could try to find out a little bit more information, and I think sometimes that can be helpful. What I find sometimes, and I was guilty of this as a journalist occasionally, was people have a certain thing they want to find out about a big project or something like that. So they will ask for everything. I want every single record related to whatever it may be. And it could be, it's a 3-year running renovation project of a high school, and there's 5,000 records because they just want everything. But maybe if you have a conversation with the person, hey, what are you really looking for? You learn that, oh, this person owns a roofing company and they want, who got the bids for the roofing job on the high school, but they aren't sure what to ask for, so they just say, just give me everything and I'll find it. But they don't realize everything is this much stuff because they don't work in town hall. So, you all that have the records are the people that know best, what you have, what you don't have. And sometimes by having that conversation, you can find a way to get the person the information they're looking for, without having to go through 5,000 different pages or to scan, 10,000 emails or whatever it is. People make large requests, I think sometimes because they don't understand how much information towns have. Towns have a ton of records, and somebody might just say, well, I'm only asking for, all the emails the first selectman sent for 6 months. How many could that be? I'm sure it's probably thousands, because, the first selectman is probably getting all kinds of emails about all types of things. So you can always ask people in there on the scope, give you keywords or give you a date range or things like that. If they don't want to modify their request, then, I would say you can tell them, look, we can do this, but it's going to take a significant amount of time. If you want to get this in a faster manner, maybe we can try to talk about this and figure out a way to handle this, that's most efficient for both of us. It's frustrating sometimes because I've had situations where, people make these gigantic requests. The town goes through and does all this due diligence, and they get them all this information, and then the person's like, why did I get so many records? And so because they made a huge request and they weren't thinking about that. So that could be something that, potentially have a conversation ahead of time. You could circumvent that. Anyone have any questions on anything we've covered so far. I see a couple.
How long are we required to keep an email or a text message that contains something that might be useful?
So for text messages, I'm not sure. I know with emails, and again, this is not FOI or records retention. I think for most sort of business emails that are not like a copy of something else, if you get an agenda sent out to you, that you don't need to retain because the town has a copy. But for sort of most business emails, I think it's something like 2 years is kind of the standard for an email dealing with board business that's not transitory. It's something that you have to retain. I think that's, to my recollection, that's sort of the standard. Important to note, with FOI, it's only records that you have. So if you deleted something and the person thinks you should have kept it, it's not something that FOI would look at.
Does the town have any relief from somebody requesting too many FOI?
So there is a provision in the law that allows them to deal with what we call a vexatious requester. So if that happens, what you do is the town would file a petition with the commission. So instead of a person filing a complaint, it's like you would file a complaint against a requester, and you would have to detail their conduct and what made it what we call vexatious. I'm just going to go, I think it's my last slide. Sorry. I just think it's important to show that because, with a vexatious requester, it's not just the volume, that's one factor, but essentially if you have someone who's making a lot of FOI requests, but also their behavior is becoming abusive, their conduct is inappropriate, that you feel like they're using FOI as kind of a weapon against a public agency, the public agency can file one of those petitions with the commission. I will say, just as a warning, it's a pretty high bar. We've had, you said the law was changed maybe 5 or 6 years ago. We've only had about, I think, maybe 13 or 14 of these filed, and to this point, some of them are still pending, but I think there's only been 2 people that have been declared to be vexatious. So it's a pretty high bar, but again, it's volume, but it's also the conduct. But if you do have a situation where you have somebody who is really abusing FOI, people have a right to obtain public information. They don't have a right to harass public officials or to intimidate people. They're coming into town hall and they're, stomping their feet and they're banging on glass and they're yelling at people. Those kind of things. When it morphs into that, or sometimes I like to say it's not about obtaining public records anymore. It's like a vendetta or something like that. When it crosses that line, then this is the recourse the town has: is to file a petition with us. We review it. If we think it's warranted, we would have a hearing where the town would put on evidence, the person would have an opportunity to rebut that, and then we make a decision. If we declare someone to be vexatious, we can bar them from making FOI requests for up to a year from that agency. So that's the only legal option that towns have. But again, it's a pretty high bar, and I think in most cases, towns try to work with the folks who make the request, but if you have somebody who is, you can't work with them any longer, they file a lot of complaints with the commission, and you feel like it's not just seeking information any longer, it's become conduct beyond that could be something that the town could do. Question in the back.
I'm wondering if there are any protections for the personal information of board members or commission members, or can personal information be given to any member of the public who requests it?
Okay, so we've got a slide on that. So there are certain personnel records that are exempt from FOI. Again, the standard on that is pretty high, and it needs to be information that is highly offensive to a reasonable person and does not pertain to a matter of public concern. So, what that means is, it needs to be, it's not things that are embarrassing. Like the situation I give is, if somebody's in trouble at work, there's an internal investigation, they're disciplined, those are the kind of things that would need to be disclosed. The types of things that probably fall under this include things like medical information, anything, in my view, that sort of reflects an employee or board member's family life or home life or things that are not really germane to their job or their board, board service. In some instances, there are some employees, and it's a different statute where their home addresses can be suppressed from public records. Employees like police officers, firefighters, judges. There's a whole list of different folks who, not as a personnel exemption, but a different law where that information can be withheld. But I think sometimes people are surprised at the level of personnel, personal/personnel information that can be obtained. But if you're a public official, even on a board or you work in town government, there is a lot of transparency into things you do related to your board or your job at town hall. Again, if it's not work related, then I would argue it probably doesn't fall under that. The other thing that comes up a lot with FOI, and this is a little quirk to Connecticut, is that we don't have an exemption for what we call PII. In the federal law, you may hear that, it means personally identifiable information. At the federal FOIA, which is different than the state, the state law, federal records requests are handled differently. There's different exemptions. So at the federal level, they suppress more of that. But to give you an example, if somebody writes a letter to town hall and they put their name and their address on the bottom, that's public, right? Even though the person writing the letter to town hall about something may not realize it, there's not, the personnel records exemption is only dealing with, again, personnel like employees, board members. So citizens who submit things to towns are not covered by this. So if somebody were to make a request for that letter, for example, sometimes maybe towns will just say, well, we're just going to redact the person's address. If the requester doesn't really care, then it's not an issue. But if that person pressed you on it or it came to the commission, there wouldn't be an exemption that would cover that address. Question?
Just to be clear, so I'm on a commission, and I had to turn in a resume and all, so my email address is on there, where I work is on there. That's public information. Anybody can go to the town hall and say, I want your resume, I want your information.
So if you filed a resume to apply for a board or commission, the resume would be public. The only things potentially that might, be things that could be redacted would be maybe something like a personal cell phone number. If you're not, if it's not a number that you use for.
Maybe or yes.
I think so with all this.
Because the town should know that.
Yeah. So the reason I say maybe is that you could redact it. The question is, if the requester presses it and there's a case before the commission, we look at each case on a case-by-case basis. And I think, to your point, I think that's the most obvious one to me would be a personal cell phone. Things like where the person works. I would argue, I understand maybe why somebody doesn't want that to be disclosed, but also I imagine where you work is very important to your qualifications for that board or commission, right? I mean, if you're, if you're a retired town planner for 30 years and you apply for the Planning and Zoning Commission, hey, this guy's got a background in planning. So I think, sort of the other information on there about your schooling and your jobs and what you do, I think that, my view would be it probably pertains to the reason the board selected you. Maybe there was something on that resume that they liked or that they focused in on, but your personal cell phone number, that they're not using that to make a decision about whether or not to hire you on that board.
My personal email address can be open to the public also.
So with email addresses, typically if you use it as if you use it in the course of your board duties, then it's a public record. So if it's not an email that you're using on the board as a commissioner, then that might be something where.
But it's
again,
on my resume, so it's already there.
So in that case, if it was a different email than the one that you use for your board or commission, potentially then maybe they redact your personal email and your personal cell phone number, but everything else I would imagine would probably need to be disclosed. What you do and where you worked and all that kind of information.
Who decides on the redaction? Do I ask the town that I don't want that there, or is it up to the town to decide if they want to redact?
So in this case, typically the town is going to be the one doing the redactions, but in my experience, a lot of times, what the law, are we still on personnel policy? So what the law says up there is that if the town believes that there's a privacy concern, then they have to contact the person and then the person has a right to object. So, we see that more often with, like, let's say somebody asks for, my personnel file, and there's probably things in there like my health insurance forms and, I was on leave when my son was born last year, so there's all that information. So, what would happen then if somebody asked for my personnel file is someone at my job who does the FOI request, which in this case is me, so it's not a great example, but somebody would come to me and say, hey, we got this request, this is what they asked for, we think there's some things here we're not sure about, what do you think? So maybe with a resume, if they felt like, we're not sure about her phone number, if she would be comfortable, then they can come to you and then you could say, I don't want the phone number to be released, but the rest of the contents I think would have to be released. Okay, so we've been sort of bouncing all over the place, but I think, just looking at the time. So there's a couple other exemptions I just want to cover because they're a little bit more common. Personnel, we've been talking about that one. Preliminary drafts and notes, this is another one. So preliminary drafts and notes, what this means is that essentially if you have a situation where there's a document that's being developed, it's still being added to, it's being modified, subtracted, changes are happening to it, and the important point is it has not gone to the final decision maker yet. So where this could come up is if you're on a board or commission, maybe you ask a town staff member to prepare some kind of report for your board. You're on planning and zoning and you want to have them identify 5 locations where they think you could do mixed-use development with residential and businesses or something like that. And while the town staff are compiling that before it goes to your board, somebody hears about this at a meeting and says, oh gee, I want to see that report. If they made a request, the town could say, that's a preliminary draft, hasn't been completed yet, it's not being acted upon or anything like that. Once it goes to a board for their action, so once it goes, it's emailed to the board members, it goes on an agenda, it's given to the first selectman who requested it for some reason, the first selectman asked the town, department heads to send in some sort of information about something. Once it's all complete and together, then it would need to be disclosed. But there's a limited period of time where it would remain as a draft, so it would not need to be disclosed. I'm going to go to the big list here just to see if there's any other important ones. So there's a lot of exemptions in FOI in our law. These are all the ones that are, not all of them, but the majority of the ones that are found in 1-210. As you see, some of this we've already covered. Records related to pending claims or litigation. There's something called trade secrets, which is a situation where a town maybe takes in confidential information from a business or something like that. To, maybe there's some kind of economic development program, and you're asking businesses that apply to share their budgets with you or something like that. That could be a trade secret. Responses to bids and RFPs, we talked about that one. There's an exemption for any records that you believe would pose a security risk if they were to be disclosed. The important thing with that one is that if you think there's a security risk, what the law says is that you need to, at the case of a municipality, you go to the state police and they review the situation. So somebody, we're talking about the school building project or the school security project before, somebody makes an FOI and says, well, I want, the copy of the school security plan that shows, all the parameters of it. The town says, nah, we're not sure about that. We think this is a safety issue. They would go to the state police, seek a determination from the state police. The state police would likely say, you don't have to disclose it. The reason you do that is that if then that person who requested it wants to file a complaint, the state police would join the town in defending that complaint. I want to make sure we leave some time for any other questions. I know we had advertised 2 hours, but I think we really covered the main points that I wanted to hit on. But if anyone has any other questions, whether it's about a records request, whether it's about meetings, anything at all, I just want to make sure that we address anything before I head out. So any other questions? Yes?
Can you talk to the ramifications of some of these things? For instance, 24-hour advance notice. It's 23 hours. Or we talked about other examples where maybe in a special meeting someone does add something to an agenda and they should have. But as board members and commissioners, what happens to us?
Sure. you know, as I mentioned earlier, you know, typically we try to work through education. So for those types of things, a lot of times, you know, most of those, you know, I should have made a note to say this. Probably 2/3 of the complaints that we get do not go to a hearing. A lot of times we resolve these, and it could be a situation like you said, they added something to the agenda when they shouldn't have. Sometimes the person who made the complaint may resolve it, you know, they would withdraw it if the board will just write a letter that says, hey, we realize we shouldn't have done this, we understand what we need to do going forward. So in a lot of cases, you know, it could be something like that, right? I had one recently where, as you know, it was settled through, I came and did a training session, and it was actually helpful. You know, if it does go to a hearing and we find a violation, a lot of times, if you ever read our orders, particularly the first time there's a violation, you know, we're not going to be too punitive, we're not going to issue fines, we're not going to, you know, order trainings unless we think there's a real widespread lack of knowledge. You know, quite frankly, I'll say, you know, the consequence a lot of times is, you know, it ties up town staff and town time because people have to go to FOI hearings, or maybe you're paying a town attorney to do this, or, you know, you're on the board, you may have to take a day off of work to go to an FOI hearing. So, you know, in my view, that's part of the process too, is you want to avoid these complaints because you probably don't want to be spending the little amount of time that you have, you know, going to FOI hearings in Hartford. But, you know, again, if it's more of an egregious violation, or if we feel like, you know, you know, not the 23 hours versus 24, but, you know, they never posted an agenda because they thought they were going to do this in secret, and they met at the McDonald's and didn't tell anyone, and they voted on the budget, you know, that could be one where we issue a fine, and we say, hey, you know, that was, you know, unacceptable, we issue a fine. And what's interesting with the fines, again, we don't do it too often, but the fine is not assessed against the town, it's assessed against, like, the person. So the chairman of the board is the one that gets the fine. It's not the town of Suffield, it's the person who is sort of the responsible party for the violation. So, you know, that could be the ultimate penalty is, you know, you could be fined as a board person, again, you know, unlikely, but that's sort of the you know, one of the things that could happen. Any other questions? Yes.
On the question of denial for an applicant, besides the letter of denial, after going to public hearing, et cetera, all the meetings you've had, and the court decides to deny the applicant, what do we owe that applicant besides the letter of denial? Anything at all? Do we need reason at the meeting to give to that denial? For that denial, or?
Is this in response to if they ask you for records, or are you just saying you have to provide them with anything? Sort of. So you wouldn't have to provide them with anything unless they ask for it. But if they ask for it, if their application was denied, and they ask for example, you know, emails about the application, or you know, things like that, you know, those would be things that, you know, that could be disclosed. In my view, I think a lot of times, you know, I work in an office full of attorneys. I think a lot of people, for that very reason, you know, don't put things down in you know, they try to do it at the meeting, you know, and have it as that's the record of what the discussion was. But, you know, if you had, you know, if there were other records related to the application, or emails, or text messages, or, you know, those could be things that they could request, but they'd have to make an affirmative request for that. You wouldn't have to just give it to them as a courtesy.
Okay, as a commissioner denies, makes a motion of denial, you don't indicate the reason why that person is denying the applicant?
If at all, I think it would be something in the planning and zoning statutes. I'm not familiar with that. So in terms of FOI, you wouldn't have to state a reason, you know. But I don't know if some difference. You know, that's the other thing too that is important to know is, you know, everything we talked about today is kind of FOI writ large, covering everything. But there could be other statutes that deal with your particular work that you do. You know, if you're on the board of public health and you're working in the health department, you know, there's different there's different statutes that cover health records and what can be disclosed. And I know, for example, with planning and zoning, you know, there are some different things. Like, I think those meetings do need to be audio recorded. I think because there's an appeal, you know, somebody appeals it and the judge wants a record of it. So sometimes there's other statutes that kind of interact with FOI, and that may be some of where that would come in. Any other questions? Yes.
What role does the FOI Commission play in supporting a decision with whether to object to an FOI request?
In supporting a decision to reject an FOI request?
If there's a question that looks objectionable, would the FOI Commission give its opinion before?
Oh, I see.
It came to a head?
So we used to do what we called advisory opinions. We don't do those too often anymore. A lot of times, you know, our view is kind of the process is the cases that we have, and we build case law that way. You know, so if there's a dispute, a lot of times, the person will file a complaint and we'll investigate it that way. I'll say, and this is sort of a good point to do this, I'll go back and give my phone number. You can always call, and we can always kind of give you, it's not an order of the commission, we can always give you informal advice. So if you want to contact, it really is me, I do most of that. You can always email us or call us, and we can discuss the issue. I can show you what the law says, I can refer you to other cases, I can give you my view on it. But the challenge of that is, even in some cases where maybe you have rightfully denied a records request, the person can still file a complaint. It doesn't prevent that, but also you may have the knowledge to tell the person, we are denying this because it is a personnel record that's exempt, or it's and the more you share that with people, I think the more likely people are to understand and say, oh, okay, they're not telling me I can't have it because they don't like me, they're telling me because, there's a law. So that's my other advice too, is if you're going to deny a records request, try to, there needs to be a legal basis for that, and try to tell the person why, explain it, and then if they understand, they may just say, okay, I understand, and then it would end right there. Before I go, I'm just going to go back here and go back. Okay. So again, it's on the website too, but my phone number, my email, if something comes up tomorrow, next week, next month, next year, whatever, please feel free to reach out. Happy to, again, give you cases, explain the law, try to point you in the right direction. And, really those conversations that I have with folks, a lot of times that can potentially head off a complaint. So if you're not sure, this can be difficult. As I started off by saying, we're not, I'm not an attorney, most of you aren't attorneys either. So know that you have resources, you have us, you got your town attorney, you can contact the first selectman, or if you have questions. And did you have one more question?
Yeah, just two quick questions. So, the exception for executive session, so discussing litigation or pending claims, so would a claim, an FOI claim, fall under that?
So not an FOI request, but if someone filed a complaint, then it would be something you could discuss. So if there was an FOI complaint and you wanted to talk about strategy, that is a legal claim that's been filed, so you can talk about that in an executive session.
And then the other thing is, if a complaint, whether or not it's resolved, how does that play out? Do you notify the town that it's been resolved if there are complaints?
So the way the complaint process works is when somebody files a complaint with us, the first thing we do is we review, before we docket every complaint, we review it to make sure that we have all the information, that it's genuine, that there's an issue that we have jurisdiction over. So if it meets that first threshold, we send out docketing letters to the town and the complainant at the same time. So what would happen is, sometimes people will tell you they're going to file a complaint, or they may copy you on the email, but until you get it from us in the mail, it's not official. So once you get a letter from us in the mail, it'll say, hello, Suffield Board of Assessment Appeals, or a complaint has been filed. We give you a copy of the complaint. On the letter, we include contact information for an ombudsman, who's someone in our office who will try to resolve the issue. We allow a period of time, usually a couple months, to try to resolve it. Like we said, through a letter, through training, whatever it is. If it's records, we try to work with the town to get the records to the person. If we can't resolve it, it will get scheduled for a hearing at our offices. Both parties go to the hearing. They make their legal arguments. The person who requested the records will talk about what they requested, what they didn't get. The town would say, well, we can give you this because of this exemption. Sometimes people will submit will submit documents to us in camera, which means a private review. So like a personnel record, that could be submitted to us privately, we review it. So we do all that, then the hearing officer makes a decision, and then you get a copy of that decision, again in the mail, and then you have an opportunity to come to an FOI commission meeting before the commission adopts it. So there's really several steps along the way where both parties have a chance to be heard. And no decision is final until it goes to our commission and our commission votes on it at one of our meetings. So there's a lot of steps in the process. We have to get through it in a year by statute. So depending on the complexity of the case, some of them are shorter than that. Some of them are pretty close to a year. It depends on a lot of different factors, how long that all takes. Any other questions? Okay, well, again, really thank you for all the great questions and the attention. And again, please don't hesitate to contact me if there's anything you think I can do to help.
Thank you.